Without prejudice to the above comma, it may further be added that the expression until the contrary is proved is couched in the negative, and the proof of a negative fact has its own limitations and bounds, and the law in this behalf does not recognize and require that a litigant should imperatively give the positive evidence of a negative fact, comma. This is inconvenienceable under the law of the proof of a fact, full stop. However, comma, the above rule is subject to certain exceptions, comma, where for example that the defendant through positive evidence shall be able to sustainable that on a given date he was not at the place where the execution of the instrument is alleged, or the plaintiff has no capacity or the mean to grant the loan, comma, or his relative met with some accident or were seriously ill, comma, hospitalized or operated upon, which would preclude the execution of the instrument, semicolon. These shall constitute an illustration of the proof to the contrary, and may be held to be one category of the cases falling within the purview of section 189, semicolon. However, comma, the second category, comma, which is pre-received by the said section is when after the conclusion of the trial, comma, on the basis of the complete evidence on the record from whichever side it is adduced, comma, that the court shall be required to determine if the execution and consideration, comma, etc., full stop, is proved to be contrary or otherwise, full stop. It may be relevant to mention that the course, comma, it shall be permissible in law to prove to the contrary by means of cross-examination upon the witnesses of the plaintiff, comma, that the instrument was not drawn and the consideration never passed, full stop. In our view, comma, the present case falls in the second category, and thus, comma, it is on the basis of the total evidence on the record by applying the rule, the evidence and the possibility that this lies should be decided, full stop.